Welcome to the Spent the Rent podcast. I am your host, Patty Rose. My guest today is author Sandra Smith Gangle, who actually is also a second cousin once removed, and we'll talk about that in a second. But Sandra, welcome to the show.
Thanks for having me, Patty.
This is really cool because, like I said, we are somehow related. So this is a little confusing, but my Aunt Mary had reached out to you, and there's my maiden name, my mom's side is Powers, and there's a family connection to the Irish history of the Powers family. And my Aunt Mary had reached out to you through a Facebook group, the Powers family history, which is really cool because we're getting to find more information going generations back. So it's really neat. And she had told me about you and said, hey, you should interview Sandra. She's got a new book, and I think it's really timely for the situation in the country. And so here we are. This is really cool.
My mother's name was Irene Powers Smith, and she was the daughter of Frank Powers, who I believe was the son of our common ancestor, Jeffrey Powers.
It's interesting because my grandma is Irene, but she was through marriage a Powers. And so it's kind of funny. Yeah. So she was also Irene Powers. Yeah. So it's so confusing that once, twice, third removed and all that. But I believe we're second cousins once removed because my mother's grandfather's brother is your dad. So, well, if that's confusing. Anyway, so we're going to talk about your book. Your book is titled Madam Arbitrator, and you were the first female arbitrator in the state of Oregon. And there it is. And anybody listening, we're also doing video on YouTube and Facebook. So if you're listening, you can listen to this in your car or whatever, or you can stop it and go watch the video somewhere on the internet. And so, yeah, I'm also going to put a plug for your website in the show notes, and so people can find out more about it. And you can go to Amazon and search for either Sandra Gangle or Sandra Smith Gangle, or you can search for Madam Arbitrator. But I'll put links in the show notes so people can find it.
Thank you.
So the book is fairly recent. Because we're very Irish, it was released on what day?
It was released on March 17th. Look at the Irish.
Right, St. Patrick's Day. So I also released some music, and at the end of this episode, I'm going to play a song that's dedicated to my mom. It's a cover song, and so we'll get to that at the end of the show. So let's start out early in your career. You grew up in the New England area.
That's right. I was born in Brockton, Massachusetts, and that is a blue-collar town. The big attraction for employees was the plethora of shoe factories. And so a lot of immigrants had come to Brockton between the late 19th century and the 1920s. And we had little neighborhoods of Italians and Swedes and Lithuanians and Irish. The town was just featured by these ethnic neighborhoods. And I grew up seeing the way that people lived and worked in factories.
Right. Really like blue collar, hardworking, didn't make a ton of pay, I'm sure. So then you went to high school there, and you had a counselor so your dream was to pursue law.
Right. And I can tell you why I had that dream.
I'd love to hear that. Yeah.
It started when I was a child. My parents separated after my father came back from World War II. And so my mother was a single parent, which was rather unusual in those days. There was a public feeling of rejection to what they called broken homes. So I felt this. I also had to go to court a couple of times with my mother in the course of the proceedings involving custody and visitation. And I wanted justice for my parents in what they were going through. But what I observed bothered me. All the lawyers and judges were men. There were no women. And I felt that they were not listening to my mother. And this bothered me. So I made a commitment early, when about age 8, that I would change things, that I would be a lawyer. And then later on, as a teenager, this feeling came back to me because we had been in an auto accident, and that is detailed in my book, where the responsible driver, the other driver, lied when the police came. And therefore, we ended up in litigation over who was responsible for my injuries. And so I had to be a plaintiff and testify in a court proceeding before a jury. And I had to watch my lawyer as he skillfully conducted the litigation on my behalf. And during that hearing, I thought to myself, he just asks a lot of questions. I could do that.
Right.
I should be a lawyer. I want to be a lawyer, and I want justice. And I want especially justice for women. So that was kind of my commitment as a young child and teenager.
That's cool. And so then in high school, you had kind of talked to a counselor and you were going to pursue it. And how did that come about? Where they basically discouraged you? Was it because you were a woman?
Yes. Unfortunately, the timing was not right. I was in high school. I graduated in 1960. And of course, we still had discrimination against women and in the workplace at that time. There still were no women in the legal profession unless their fathers or grandfathers happened to be lawyers or judges. So when my counselor asked me what I wanted to study in college, I told her I wanted to be a lawyer. I wanted to study law. She scowled and she said, well, you know, if you go and you go through all those years of study and get a law degree, you won't be able to get a job, except as a secretary. And you could do that right out of high school. She said, you're a good student. And there are other things that you can do. And she said, so I don't recommend that you go into law. I think teaching would be a good career for you. And so she persuaded me that because I was good in foreign languages, that maybe I should study foreign languages in college and become a foreign language teacher.
Right. And, you know, I mean, in her defense, I'm sure that it hurt to hear that, but at the same time, she was probably trying to protect you. And it's unfortunate, but I'm glad you didn't take defeat, you know, that you did that later. Now, you mentioned going to school to become a teacher, and that's what brought you to Oregon. So you can tell us a little bit about that.
Yes, thank you. My undergraduate was on the East Coast. I went to the College of New Rochelle, a women's college in New York, and I studied French and German. And I really thought, being in New York and being close to the United Nations building, that maybe someday I could be a translator for the United Nations. But, you know, I found out that the people that got those jobs were from the international community, and many of those people spoke 2, 3, 4 languages.
Sure.
So the chances that I would be able to become an interpreter were very slim. But teaching was certainly still an option. And I was hired in my hometown of Brockton to teach conversational French at the middle school level. So I did that for 2 years. And in the course of those 2 years, I was fortunate to be selected to attend the programs that were specializing at that time in training teachers how to use the audiolingual method to teach foreign languages. Before that time, teachers always had students memorize vocabulary and translate passages and read and translate, but not ever speak the language.
Oh, wow. Yeah.
But the new audiolingual method, which really had been fostered by President Eisenhower, because he believed in finding peaceful ways of solving problems. And so he encouraged Congress to pass the National Defense Education Act. So these programs were offered through congressional funds through the National Defense Education Act. And my first institute under this program was at Notre Dame University in 1964. And then a year later, 1965, I was selected by the University of Oregon to participate in its program, which was conducted in France. So I spent the summer in France. And during that program, of course, I became acquainted with the staff and faculty from the University of Oregon. So in conversations with them, I told them that I was thinking of going back to school and getting my master's degree so that I could teach at the college level. And they encouraged me to apply to the University of Oregon, which had an excellent program in foreign languages at the time. They said, we can't guarantee anything for you, but you would certainly be good consideration for financial assistance. So I did. I applied and was given a teaching assistantship at the University of Oregon. And I, at that point, said to my mother, Mom, you've always wanted to go out west. You've always wanted to be free of Brockton and the problems of the past. Come with me. We'll have a new life in Oregon. My brother was a freshman in college at that time, and so he came with us. The three of us were like pioneers coming across the country. Right. And we arrived in Eugene, Oregon in late June of 1966.
Which I'm sure in Eugene during that time was a pretty wild time.
It actually, it was, I loved it.
Oh, it's great. I mean, and I mean that in a positive. There was just a lot of culture, and yeah, the counterculture brewing, which when you're in college, that is, even if you're not involved in it, it's really exciting because you can learn so much about humanity. And so we still see that today. I've lived in Eugene since I was 11 and Oregon my whole life. And you lived in Salem as well for quite a few years, and we'll talk about that as well. But yeah, I mean, there's something about Oregon. I've never left, but everybody that I've talked to says it's like a vortex. If you leave, then you're going to come back. It's just too hard to get away. And
I knew the first day that I arrived in Oregon that I was going to stay. I loved the scenery, the mountains, the wide open spaces. The first thing I bought in Eugene was a pair of hiking boots. And I signed up at the University of Oregon for weekend hikes in the Cascades.
And it's cool that a college would even offer those types of courses, so that's pretty cool. So then you received your law degree from Willamette. So after getting your master's at Oregon, you then worked as a teacher. Is that correct? Teaching French?
Yes. When I got my master's, I was hired at Oregon State University to teach wonderful advanced courses. As it happened, the head of the department had an injury and was unable to teach. They didn't know whether he would ever come back, but they did not want to look for someone with a PhD as a permanent position because this head of department might recover sufficiently to come back. So I was the perfect choice for them. I was a strong student in foreign languages, and I had just earned my master's degree and had the recommendation of the University of Oregon staff. And so they hired me, and it was a wonderful position that I just loved. So I moved to Corvallis. My mother stayed in Eugene. At that time, she was working for the Eugene School District, and was very happy living in Oregon. I moved to Salem and met my husband, Eugene, and then he got a job teaching at Corvallis High School. So after our engagement, a few months after our engagement, we were able to plan our wedding in December of 1968. And then a couple of years later, he got a better job in the Salem School District. So we moved to Salem, and I was still commuting to Corvallis, but I knew it would be always temporary. So when an opening came up at Willamette, I took that and I taught at Willamette. Meanwhile, I had my daughter, Melanie, and then my son, Rocky. So I was teaching and being a mother all at the same time, very busy with life. But I never forgot my early commitment that what I really wanted was practice law. So I was aware that the Congress had passed legislation in 1964 called the Civil Rights Act of 1964, which through a miracle, really, the word sex was included as one of the protected classifications under the statute. It was a statute that was originally designed to prohibit discrimination on the basis of race, color, religion,
Right.
national origin. But a legislator put in the word sex at the last minute with the expectation that that would kill the bill. Well, it didn't kill the bill.
Oh, wow. I didn't know that.
As a result, the whole issue of discrimination against women changed.
Wow.
Slow. It was a slow progress, but by the mid-70s, it was really reaching down into the legal profession and medical profession and so forth. And I was pushing my children in a stroller across the campus one day, and I happened to notice that a group of women was going into the law school, and I thought, yes, women are now entering law, then that means that there are jobs and there's a future for me. And so I told my husband that the time was ripe and I would like to enroll in law school. I was 34 years old.
Wow. I want to touch on that comment that part of that. I was not aware of that in the civil rights bill, that was thrown in as an attempt to have it not go through. That says something.
Exactly.
Because, a lot of people don't realize, and I'm not super versed on history, I'll be the first to admit it, but a lot of people don't realize that women did not receive the right to vote until after people of color, which is really interesting. I mean, is that true? That's true, right? I mean,
well, men of color received the right to vote in 1870.
Yeah.
Women of color, just like white women, could not vote.
Yeah.
It was the women suffragists, who had to fight a very long battle for 70 years before it finally went through. The 19th Amendment went through. And I just finished reading a book last night, which recently came out, called The Woman's Hour by Elaine Weiss. I recommend it strongly because it gives the details of the ratification of the 19th Amendment. There have to be a 3/4 vote in the state legislatures to ratify something once Congress has passed an amendment to the Constitution. And Tennessee was the 36th state to ratify it. And it was not an easy process. It was extremely contested, not only by men, but by women called the aunties, they didn't want to go to vote. They thought it was just wrong for women to want to be involved in
their own. Yeah.
It's a very good book. And
that's
you should read it.
One more time. What was that book called?
The Woman's Hour by Elaine Weiss.
Cool. That's a good plug. So if anybody's interested, after they read your book, of course. No, but so, Willamette High School, Salem, you fell in love with Salem, became your home. And then when you did get your law degree, you did something a little different. So instead of going to work for someone else, you did work for someone else for a short time, correct? But then you started your own law practice.
I worked for someone else only as an intern. I worked for a local firm, and they were extremely helpful. And they didn't just make me run around and serve process on parties and file the mail. Sure. They actually had me doing research and writing in their cases. So I learned a great deal about the subject matter, the areas that I wanted to practice in myself. My goal was to open my own office and to be a sole practitioner. I did not want to just work for a firm and get a salary and do what I was told to do. I wanted to represent real people in the community,
right,
in problems. And so, yes, I was fortunate to have an internship while I was in law school where I got that kind of training. I also interned, and this is in my book in great detail, with one of the professors at Willamette Law School. His name was Carlton Snow, who was a very well-respected arbitrator in the Pacific Northwest. And he knew that I was interested in employment issues. I had been taking all of the courses that were offered in labor relations, arbitration, labor law, and contracts, and that I wanted to be involved in the elimination of discrimination. I wanted to represent clients who were alleging discrimination in employment. So he took me on as an intern, and in my book, I detail to a great extent the advice that he gave me that was very, very, very helpful in my own formation of my career.
So when you formed your own practice, what kind of stuff were you doing primarily?
I never did criminal work. I decided early on that I would just do civil work. And so, there were opportunities to represent people who were being committed to the Oregon Mental Hospital and who did not have the money to represent themselves. And so that was one source where I, was basically on appointment by the court to represent clients who were being committed to the hospital and who were objecting to their commitment. But in addition to that, I represented people who wanted me to write wills, land sale contracts, and I let it be known to other lawyers in the community that I was interested in representing people who were alleging employment discrimination. This was an area that was not very popular among lawyers because it was risky, and it was very hard to find a case that really was a good case that had promise and that lawyers were willing to take the risk of spending their time on. So I got a lot of appointments and referrals for those. And those are some of my early cases are outlined in my book.
Right.
That's how I got my start in the employment area. But
No,
the areas that I actually wanted to focus on were the employment issues and also land use, since that was certainly a big issue at the time. I heard one of your speakers, one of your earlier interviews, that was interested in land use, and he talked about the land use law. Well, the land use law, the Oregon's goals, had just been passed in 1973, and they were still working their way through the courts and were certainly a very hot issue in Oregon. And so really, I was one of the early lawyers that was involved in those cases.
You mentioned Thomas Fiorelli, and that he was one of
Yes.
my talked about housing in Lane County, and man, he is passionate. This is what I love, about what I do, is I get to meet people and learn more about it. Now, your book is called Madam Arbitrator. So tell me what you would say an arbitrator does. And I have a couple follow-up questions about some of what we see in today's arbitration, where the system is stacked against people even today. So first of all, tell me a little bit about what, an arbitrator does. When you were working in law, would you call yourself, what is it? How does somebody become an arbitrator specifically?
It's a long-term process. There is no actual, there's no formal training program. There are some programs nowadays through American Arbitration Association and through Cornell Law School and that sort of thing. But in my day, no, it was a matter of developing your expertise in labor relations and then establishing credibility among the labor relations practitioners. And that's two groups, the union representatives and the management representatives. And once they trusted you, once they understood that you really understood the labor law and what a collective bargaining agreement was all about, and that you were fair, that you were not biased in favor of unions or biased in favor of management, that you could be trusted to listen to the evidence and to make a fair decision like a judge would in court, then you can be approved by the bodies that approve parties as arbitrators. And so, yeah, the first step for an Oregonian was to be approved by the Oregon Employment Relations Board, and they manage, or they are the body that governs the labor relations issues for the public workers. In other words, the teachers, the police officers, the firefighters, public employees. And so usually your first few cases are within your own state.
Right.
Then once you have that kind of approval, you go to the federal agency, which is the Federal Mediation and Conciliation Service. And then they do the same thing. They approve arbitrators based upon their experience, their history, their credibility with the parties, and put your name on lists that go out to the parties. In private sector cases, that means industry.
Right.
So
the thing, real quick,
it's a process. It's a gradual process.
Right. So when I think arbitrator, a lot of times what it should mean is impartial. Like you just said, it should mean somebody
exactly
on both sides, and they can really work towards finding a solution that can work for everybody, which we're going to touch at the end of this. I have a couple questions. I want to talk about the current landscape in society, but we'll get to that. But the thing I wanted to touch on is that in today's world, a lot of people aren't aware. I watched a really good documentary called Hot Coffee, and it was about tort reform. And there was this whole thing about arbitration agreements in it. And what happens nowadays when you sign a contract for your iPhone or for anything you sign, or employment, even when you get a job, you sign a contract for the employment there that sometimes waives your right to impartial arbitrator, where the arbitrator is chosen by the employer. And this is horrible that this happens, because what that means is that, say that you go to work for, I don't want to throw a company under the bus, so we'll just say a corporation. Okay. And so you go to work for this corporation, and they then, if there's a conflict, they are the ones that get to pick the arbitrator. And if they're on the payroll of that company, that can be a conflict of interest. And so a lot of times, so it sounds to me like what your passion was in is truly representing the people, or the management, or the unions, is not representing either one, is finding the resolution between the two, like the mediator. Okay.
You have raised a very important issue, and I need to describe the difference. Okay. I never accepted any cases in what's called employment arbitration.
Right.
And I explain that clearly in the one, I believe it's the last chapter of my book, because I had misgivings about the things involved, and I don't want to.
I don't want to mislead anyone either. Sorry, but if that's the way it was, but go ahead.
Yeah, no. Now those agreements, what are called employment agreements, are unilaterally drafted by the employers, and then they are presented to the employees when the employee is hired, and they're told, oh, by the way, we have a dispute resolution process here, and we want you to sign this before you can start Monday morning. And under Oregon law now, the employer has to do that. I believe it's 48 hours before the employee is actually hired. In other words, they're given a period of time to read it and probably talk to their family, or hopefully talk to their lawyer about it. But in the past, no, it was just handed to you. Sometimes it was just included in like a booklet that was given. There'll be these policies that the company lives by. Okay, that's a wholly different process.
Yeah, sure.
Clear. Wholly different from what I was involved in, which was labor arbitration.
Okay.
In labor arbitration, the union and management negotiate their labor contract. And the contract includes provisions for wages, hours, terms and conditions of employment, and usually a dispute resolution provision.
Right.
In the dispute resolution provision, they agree to have a grievance procedure, where if the employee feels that something has been done improperly by management, they can file a grievance. The representatives of union and management try to resolve it among themselves. And if they're unable to resolve it, then they submit it to arbitration, and they jointly select their arbitrator. It's not just selected by the employer.
That's so important, with arbitration.
Okay. That's the process that I was always involved with. That's the process that I believe has the best credibility, and basically you have a law of the case that you can apply. The law of the case is the collective bargaining agreement.
Yeah. And see, this is, and again, as an arbitrator, you try to be impartial or are impartial. And so
exactly, you have to be.
This is the true benefit of unions in a lot of cases, because the labor argument, they have to do their job. They have to make their money. They make profits. That's what they're in business for. The unions are to protect the employees. So when people get a job, and I know that I understand, and I want to make it clear that that's not the work you did, is employment arbitration, but I just want to touch on it so that people are aware, so maybe they can do their own research, that when you get a job and you are, especially if it's an entry-level job or low-level job, maybe, I don't want to say unskilled, I don't like that term, but someone gets a job, they a lot of times waive their right to any type of impartial arbitration. So I really want people to do a little bit of research on that separately from this. The documentary Hot Coffee is an incredible documentary. It's an HBO documentary, so I think it's on Xfinity On Demand and Netflix and all that. So, but
the situation has even been aggravated this past year by some Supreme Court decisions, which authorized these employment arbitration procedures to substitute for courts in cases that used to have to go to court, like employment discrimination, race discrimination, sex discrimination, age discrimination, and even cases involving wages, like overtime, that sort of thing. And if once you had signed this particular agreement, then you had agreed that those cases would no longer go to court. If you had a claim like on one of those issues, it would have to go to a private arbitrator.
Yeah. And it's something people aren't aware of. It's they get a job where they're making maybe 10% over minimum wage. I'm not going to say the number because it changes over decades, because of the cost of living. But people will get a job, and then they basically are signing away their civil rights, and they don't realize it. And then what are you going to do? Because you need this job to pay your rent and all that kind of stuff. But I don't want to go too deep into that because, like you said, you were not focused on employment arbitration, labor and union, which. There's a joke I heard about a union. I'll throw this in and then we'll move on. But one time, and it was during the Tea Party movement, and it said there's three guys sitting at a table. There's a union boss, a corporate CEO, and a Tea Party voter. And the corporate CEO, and there's a dozen cookies between them. The corporate CEO grabs 11 cookies and says, that union guy is trying to take your cookie. So it's like a pro-union joke, I guess. But anyway, so moving on. So the book, March 17th, it came out, Madam Arbitrator. It talks about a lot of the stuff that we're talking about, kind of how your origins in the law career and what made you passionate about it. One of the things, if you go to your website, which the link is going to be in the show notes, as I mentioned before, the subtitle of the book is Working Towards Social Equality and Employment Justice. Now, what does that mean to you?
Well, that's basically my philosophy. I really believe that we need to have fairness. We need to treat people based upon their qualifications and who they are as persons, their values, their morals, not their race or their age or their gender. Therefore, I think that so many of the issues that right now are so public that they have been, I think people's awareness has been raised by issues that just came out since my book came out. And I think that that's been really my focus for many, many years, social equality, and employment justice.
And we kind of mentioned employment justice already. We talked about that you try to be somebody that's impartial, that can because obviously there's both sides to this disagreement when it comes to the unions and the labor management, because they have to both do their parts, to unions protect.
And I also point out in the last chapter of my book that I am very troubled by the downturn in unionization that occurred in our country, because I did believe that unions were a very strong factor in the middle class life that my generation was able to achieve back in the 60s, 70s, and 80s. And that has gradually deteriorated. And so my children and other young people now just simply cannot acquire their own the way of life that I was able to achieve.
Right. Well, you had mentioned, and these are my words, you had mentioned Eisenhower. And one thing I talk about a lot on the show is a time that America was great in people's, in quotations there, in people's minds, was a time when unions were very strong and unions went to bat for the employees and for the people. And so people had a living wage that could support a family on one income, which is unheard of today. And then also you had record high corporate taxes so that the businesses, it was like 80% or something crazy. Now it's like 15, but it was so that business owners would have to make a decision at the end of the year when they were going to do taxes. They would then compensate their employees, like they would take care of their employees. So employees had such a better way. So they're getting fed this whole thing. Let's make America like it was back then, when in all reality, the one side has destroyed any resemblance of that. And it started with Reagan, and it's continued on today. Trickle down economics, it just doesn't work. And I know you're not here to talk about partisan politics, but it's crazy how people say that. Eisenhower, from what I've done research, was somebody that really wanted to make the country the best for as many possible people. And that should be all of our goal.
Right. You mentioned the power of the corporations. One of the points that I make in my book is that the wage separation between the wage earners and the corporate managers and owners and investors, it has gradually spread to dramatic levels, and this troubles me.
Oh yeah.
There is no need for the higher management people to have such a huge advantage financially over the workers who create the work, basically, that makes their jobs possible. It troubles me because in the history of unions, the way that unions operate is they have to sit down at the table with management and explain their needs and the work that they do. There's a discussion where management learns more about their workers. And they have to acknowledge the value of the work that's done. And they have to disclose the profits. They have to show how the business is using the money that comes in. Without the unions being involved, without that collective bargaining negotiation process, they can hide things. They can pretend that we just can't afford this, and we can get workers from wherever that will do things for less, and so that's all we're going to pay. They just don't listen, and that just creates more and more division, and also it hurts. It hurts the workers that they are not valued.
Their value and their psyche. So that actually gets a good segue into one question I wanted to touch on about arbitration in everyday life and in normal society. Because what happens with racial and gender equity, that is something that we need so desperately in this country, is that people need to be brought. People say, okay, equality. Well, equality is not enough. We need equity for people that have been marginalized. So what that means is that, like you just touched on in labor discussions, it actually transfers over very much so into everyday life, because what we need people to come together and hear each other's experiences, and so that they can then see not only their value, but their similarities. And so this is where it gets lost in corporations that are not people. That's why corporations should not be considered people. And that was probably one of the lowest points in our country recently is Citizens United, or whatever it's called, where it basically gave speech to the corporations, and it squashes the people because they decide they can outspend us as individuals. And so it's really frustrating. So I guess my question is, are you optimistic that we will find leaders in society that can be quote unquote arbitrators that can basically kind of listen to both extremes when we live in a society where people have just had enough. People are almost done listening to the other side because they feel that the other side is not listening to them, you know, and that's where we need to find leadership in an arbitration or collective bargaining type process. You know, I don't know, that's a long-winded question, but.
Well, I think that you're struggling to apply a process that has been implemented in the employment area where there is a union contract. You're attempting to apply that to society, and the comparability is the law. You know, we have already a justice system with law. The law is designed to protect the people, and we choose our representatives from the people to make the law and then to apply the law. So the equivalent of a lawyer, of an arbitrator in society is a judge. Now, I think that what you are talking about is how do we find a way for someone who's not necessarily a judge, who's going to decide who's right or wrong and issue some kind of an award, but
Sure.
someone who's going to try to help them to listen to each other and collaborate to find processes that will work better. And I think that is more of a the process called mediation.
Yeah.
And we do have now a growing cadre of mediators who are skilled at doing exactly what you were talking about, of bringing people together. In my book, I explain that in my career, I wore many hats. As a lawyer, I wore the lawyer hat. I was an advocate. When I represented a client, I spoke for that client. I fought for that client against someone else. Okay, that's the role of an advocate lawyer. When I was an arbitrator, I put on my judge hat, and I looked at the law, which was the collective bargaining agreement. I listened to the evidence that came in. These what the parties told me, and I had to listen carefully to both sides, because sometimes it really sounds like one side has got the entire case in a bag, but you have to then wait and listen to what's coming in from the other side, because that can change the whole focus of what you have heard from the first side. And then you make a decision. So that's the arbitrator role. But the mediator role is neither of those. The mediator has no power to make a decision. The mediator is not applying a law. The mediator is helping parties to listen to each other and to establish a process where neither side is taking advantage of the other, neither side is monopolizing all the time and resources, but they're working together with a common good faith. It has a requirement. They have to be acting in good faith, with the goal of reaching some kind of a reasonable decision. And usually that means a compromise.
Yeah.
Arbitrators don't compromise.
That's such a good way to put it. I really appreciate that, because this is why I love what I do, because doing this show, I get to learn so much about people and what they're passionate about. And it allows me to grow as an individual, because that you nailed it. Because like you just said, it's like with arbitration, you're making a decision. With mediation, you get the two sides, and all you're trying to do is then listen to them and then probably explain what you've heard, and then they can hear that, and then they have to come to their own decision, you know? And so I guess all of us are thriving so much in society to find leadership that we can turn to, where it can kind of paint a picture for both sides. And so we can find common ground. You know, with protests, it's hard for people to wrap their head around when they see people marching in their streets or in front of their businesses and whatnot. And I know that's not what we're talking about today, but sometimes it invokes fear, and people are like kind of shutting in. And right now we need to be opening up. And so it's really difficult for us to all come together. So I know that we need leadership. But anyway,
if I could give you a couple of examples of mediation.
Sure.
I did a lot of mediation involving persons with disabilities under the Americans with Disabilities Act, because as you know, the business community was troubled when they were suddenly required to put ramps in for wheelchairs and to hire interpreters for deaf people. And, there were many steps that seemed to be an unnecessary expense, because how many people in chairs would they be serving anyway? And they also had the fear that if they didn't immediately spend lots of money and make lots of changes, that they would be sued and that they would have to pay lots of damages. So there was fear that was rampant. And what was put in place was a process whereby parties who were persons with disabilities who had some kind of a complaint could file a complaint, and the complaint would be processed through the U.S. Department of Justice, and both parties would be asked, would be willing to mediate this case, to submit to a mediation to discuss the complaint before it is investigated and submitted to a decision maker who might award damages.
Right.
And invariably, the parties said yes. As it turns out, the main goal of the complainants in those cases is to get access to the business that they have filed a complaint against.
Right.
They're not looking for damages. They're looking to do business there,
And to be treated like everybody else, So
right. So I had a number of those cases, and what I found was that by sitting down with me, and the business then would be listening to this person that had difficulty either getting in the front door of the business, getting up the stairs, or communicating in some fashion. And they would empathize. They would empathize with the needs of that person. And they would say, well, let's see, what would you need? And they would ask questions that would then help them to know, how can we make the changes to our bathroom or our processes that would make it more welcoming to you. And usually they would agree to hire an architect or a contractor who would come in and make whatever changes would be necessary to accommodate not only that particular person, but other similarly situated people. And oftentimes what they found was that not only were they helping a person in a wheelchair or an elderly person or a blind person, they were helping a mom pushing a baby carriage, or families that were having similar difficulties where nobody was particularly disabled, but they were disadvantaged by the particular barrier that had been affecting the person with a disability. So by listening and by looking creatively at problems instead of using fear and shutting the door,
right.
Things were improving as a result of the Americans with Disabilities Act.
Right. So I want to encourage anybody listening to or watching to go to the website in the show notes. It's got the link is in the show notes for your website. It explains more in depth, and it's got some testimonials about your book from some people in our community. The last question that I have before I play a song and we get out of here is, who you want to read your book. Obviously everyone in the world, so that you can sell as many copies as possible, but no, there's kind of a target audience a little bit. You can kind of touch on that.
Well, I think that my main purpose is to give some guidance to young people who are looking to enter a career that they believe is either closed to them or that they just don't understand, and they feel that they'll never be able to achieve acceptability and get work in. And especially, I think people of color. I'm concerned about people of color getting into the legal profession, and especially into the fields that I was able to get into, arbitration and mediation, because those fields are still heavily dominated by white males. The white females have managed to get in the door, but we still don't have a great strong percentage either. But certainly the persons of color are still struggling to enter. And I think that I would encourage young people who are intelligent, who like to read, who like to write and be involved in legal and academic issues, to not just give up and do something else because they think that they'll never be able to get into the field. I believe that by following some of the guidelines and steps that I took, they will give it a try, and we will see the numbers increase. I also want to encourage the decision makers themselves to be mentors, to welcome young people of color, and to give them the hope and the skills that they need in order to get into these careers.
Well, that's pretty great. So it sounds, your story is very inspiring, and it's obvious in the way that you would tell it that it's been very fulfilling for you. So
it has.
It is a real pleasure to meet you formally, because we're family, essentially. It's kind of crazy. And I am going to Ireland in March. And now that we are acquainted, we'll be keeping track of each other on social media, and I'll touch back with you down the road and see how the book is going. And because I know you're doing the circuit now, you're kind of getting the word out about it. So this has been a cool opportunity to get to know you, and I look forward to having a good friendship with you. And so thank you very much. Madam Arbitrator, Sandra Smith Gangle, it's really great to finally meet you. And I know Mary's watching. Shout out to Mary Ball, my aunt, for making this happen. And so I want to end this with a song that is dedicated to my mom. And it's a real bummer for me that my mom never got to meet you, because she would have adored you. And so this whole thing happened because of her, because I wanted to, when you had reached out to me and I opened your website, the first thing that I saw was what you just touched on who should read the book. And I was like, to me as a podcaster, I was like, jackpot, because this is the kind of stuff I wanted to do. I wanted to tell stories of the underrepresented, because like you said, not doing criminal work, that's flashy. That's really, people that draws eyeballs. Doing arbitration, doing, mediation, even though that wasn't your area, which we touched on, but it's something that's so crucial to what makes a society. And so I think it's cool that we can learn a little bit more about that today. And so I thank you for that. And my mom would have been tough.
And I thank you.
Yeah, you're very welcome. So we're going to end this with a song. This is a cover song of The Rose. So this is me, Patty Rose, with The Rose. Sandra, thanks again.
Thank you.
Some say love, it is a river that drowns the tender reed. Some say love, it is a razor that leaves your soul to bleed. Some say love, it is a hunger and endless aching need. I say love, it is a flower, and you, it's only seed. It's the heart, afraid of breaking, that never learns to dance. It's the dream, afraid of waking, It's the one who won't be taking, who cannot seem to give, and the soul afraid of dying, that never learns to live. And when the night has been too lonely and the road has been too long, and you think that love is only for the lucky and the strong, just remember, in the winter, beneath the bitter snows, lies the seed that with the sun's love